Awesome. Okay, good afternoon. My name is Tim Onajobi, Team Lead Institutional Trust and Loan Agency, Stanbic IBTC Trustees. I want to welcome everyone to this webinar today, hosted by Stanbic IBTC Trustees, where we'll be discussing the vital role of the Security Trustee in a corporate lending arrangement. We're hoping that by the end of this session, you have a very good understanding of the role of a Security Trustee. And for those that are familiar with the topic, we'll be able to answer a lot of your burning questions. We promise that it's going to be an engaging session with enlightening discussions. So we'll kick it off by having the opening remarks, which will be taken by our Executive Director, Stanbic IBTC Trustees, Amy Agaba Oloja. Amy, over to you.
Thank you, Temitope. Good afternoon, ladies and gentlemen, and thank you for joining us today. I am truly honored to welcome you to this insightful webinar, where we'll discuss a topic of utmost importance in today's corporate landscape, the vital role of security trustees in a corporate lending arrangement. As stewards of trust and guardians of financial integrity, security trustees play a pivotal role in ensuring the stability and resilience of lending arrangements within the corporate sector. Therefore, as we navigate the dynamic terrain of corporate lending, it is important that we recognize the evolving nature of risks and the need for adaptive, proactive strategies to address them appropriately. Throughout this webinar, we will delve into the details of the responsibilities of security trustees, examining how they help to balance out the interests of lenders and borrowers, their expertise in evaluating and mitigating risks, safeguarding assets, and upholding contractual obligations form the bedrock of secure lending practices. Our distinguished panel of experts will share their valuable insights, shedding light on best practices and emerging trends, and help us to give depth to our understanding of this critical aspect of corporate finance. At the end of this webinar, I am confident that you would have gained a comprehensive understanding of the role security trustees play in ensuring the sustainability and success of corporate lending arrangements. Without taking more of your time, let us embark on this enlightening journey together. I encourage you to actively engage with our speakers, ask questions, and share your thoughts. Once again, welcome to this session, and I wish you a productive and enjoyable time. Thank you.
Thank you very much, Amy, for the opening remarks. And now we're going to be moving to the introduction for the panelists. So we're having two panelists today, distinguished panelists, that will be taking us through this topic. Our first panelist is Mr. Okey Nnebedum, and our second panelist is Mr. Ekundayo Onajobi. Okey is the co-sector head financial services at Etti Edu. He's a corporate banking and finance and commercial law specialist. Okey is noted for his in-depth knowledge and understanding of corporate law, banking and finance, and business advisory. Investors, corporates, startups, fintech companies, consultants, and global law firms trust him to come up with knowledge and experience-driven solutions in transactions. Okey is an executive member of the International Trade Law Committee of the Nigerian Bars Association section on business law. He's also a member of the World Association for Medical Law. He has extensive knowledge of business and regulatory advisory and has also co-authored Etti Edu's Doing Business in Nigeria manual. Okey is a graduate of Oxford Hall Law School and University of Benin. Okey, you're very welcome. It's a pleasure to have you.
Thank you for having me.
Our second panelist is Ekundayo. Ekundayo is a legal practitioner qualified to practice in Nigeria. With over a decade of hands-on experience, he has consistently advised a diverse range of clients on mergers and acquisitions, capital markets, real estate, wealth management, and general corporate advisory. He works with Udoma and Belo-Osagie, one of Nigeria's top-tier law firms, and has been consistently ranked by global legal directories in recognition of his competence. Ekundayo, you're welcome, and it's a pleasure to have you.
Thank you very much.
Awesome. So now we'll be moving into the item of the day, which is the panel discussions. This webinar is going to be in two phases. The first phase will be the panel discussions, and the second phase will be the question and answer session. We'll be opening up the floor to receive questions from the audience and also get responses from panelists. So our first question here, this is for you, Okey. Who is a security trustee, and what criteria are typically considered by the parties in the process of selecting a security trustee?
Yeah, thank you, Temi. So I will start by just giving a brief definition of who or what security trust arrangement is and who a security trustee is. So security trust arrangement in a lending transaction simply means appointment of a trustee to hold and manage security in trust for the benefit of the lenders. A security trustee is any party who has been appointed either by lender or by a borrower to hold assets as security or collateral for the benefit of the lenders. So that is the simplest definition of security trustee or security trust arrangement in relation to secured lending. Now, there is a difference between a security trustee role and the security trust agent role or agency role. I know for those who are very familiar with loan documentation, you would probably have seen a situation where in certain instances you see security trustee and in certain cases you see security agent. They're actually totally different. A security trustee, unlike an agent, occupies a position of trust and confidence. It has a fiduciary duty, which is a duty to act in good faith in the interest of the beneficiary. So a trustee may be exposed to liability under common law for breach of this duty. An agent, on the other hand, does not have fiduciary duty. So where a principal may be liable for the actions of an agent, the lender, on the other hand, does not have liability for such, does not have such liability for actions of the trustee. Although cases where trustee acts for sophisticated entities like lenders, the courts would likely rely on the duties in the trust agreement. So they would lay less emphasis on the fiduciary duties in such situations. There are a couple of factors to be considered when selecting a security trustee. First is that the trustee has to be an incorporated entity and a licensed entity by the Securities and Exchange Commission. So it has to be licensed to operate as a corporate trustee. That's the first consideration. So you need to know that you're dealing with a duly licensed security trustee. Then you will consider reputation, you consider pedigree, you consider expertise. Now, this is very important, not just to the lenders, but also to the borrower. Each party needs a security trustee who understands the role and not just a pushover or a stooge of the lender or borrower. So you need a security trustee who understands the role of security trustee and what it means, the liabilities, the obligations. A borrower would like to know that his assets are protected during the security period. Because it's a security, it is not a total transfer of assets. So as a lender or a company who is involved in a security trust arrangement, you want to be sure you are dealing with a security trustee that keeps your assets for you safe. And that its title documents are safe. So you want to be sure you are dealing with a reputable organization. So they need a trustee that provides solution and communicates effectively. In the same vein, lenders need a trustee that they can trust with their secured interests. The trustee has to be known to be transparent. In security trust arrangement, transparency is often key. because you're dealing with different entities with different interests. So there has to be a very transparent process throughout the period of security trust arrangement. So the lenders want to have a security trustee that guarantees that level of transparency. And then a security trustee that has capacity in terms of knowledge, in terms of network, and also network and the ability to meet timelines. So he has to have a wherewithal to be able to enforce security. So I think in a nutshell, those are the critical considerations that parties would consider when considering taking a security trustee. Thank you.
Okay, thank you very much, Okey, for your response. So the second question goes to Ekundayo. Why is the role of a security trustee essential from a lender's perspective? How does the appointment of a security trustee benefit the lender in a corporate lending transaction?
Okay, good evening, everyone. The role of the lender, I thank you, Okey, for providing the background, and I will just build on what Okey has said. The role of a security trustee in a lending transaction is quite important, because if the transaction is such, and I would not want to assume, so I'll lay the foundation, if the transaction is such that it's a secured transaction where the borrower is going to be creating security interest, or what is called, is going to be creating collateral, is going to be providing collateral to the lender as consideration for the loan, then the role of the security trustee then becomes important, and it is important for quite a number of reasons. Now, one, where your lender is incapable of holding that type of security, then you will need somebody that has the capacity to hold that security. For example, if you want to create interest in land, generally under Nigerian law, a non-Nigerian entity cannot hold title to land. So it means that if a foreign lender wants to provide funds to a Nigerian borrower, and the consideration for that transaction will be a mortgage. And remember, a mortgage is the conveyance of your legal title as consideration for a loan. So where the lender is incapable for legal reasons, or due to legal restrictions, of holding the collateral, then such a lender will require the services of a Nigerian security trustee to hold that asset on their behalf. So the lender provides the loan, but the security trustee holds the asset. So that is one instance where you need the services of a security trustee. Now, two, if you deal with organizations that I will call who are serial lenders, who are professional lenders, you will find that the bulk of the time they are busy with the commercial side of the deal, i.e., analyzing the loans, analyzing the payment ability of the borrower, and every other thing on the commercial side. So they do not want to be bogged down with the nitty-gritty and the details of what has to do with holding the security and ensuring that the filings are made, and every other thing that you will have under that your security trustee will have, the duties that they will have to perform. So in that instance, you would want to hive out that part of the transaction to someone who you believe is capable of doing that. So for professional lenders, so for example, I have not seen, I stand to be corrected, but you almost will never see your DFIs, your developing financial institution, even though they are professional lenders, you almost won't find them holding the security by themselves. They just hive off that work stream to your security trustee. And another reason why you may need a security trustee is it is easier when the relationship is bilateral. So it is you have Temitope wanting to provide loan to Okey. A bilateral relationship, your lender and your borrower are clear, and you can create security in the reverse. But where you have transactions that you have up to 10 lenders, up to 15 lenders, the question then is this: who holds the security? Who holds the security? So these are some of the reasons why the role of a security trustee is important. Just to recap: one, where the lender is legally restricted or legally incapable of holding that kind of those kinds of security. That is one. Two, for administrative convenience. Three, where you are having a syndication when you're having a syndication, a syndicate of lenders, these are some of the instances that really makes us to see that the role of the trustee is quite important.
Okay, thank you very much, Ekundayo, for that in-depth response. The next question goes to Okey. So we've spoken about the importance of having a security trustee from the lender's perspective. Now we want to take it from the borrower's perspective. We know that companies are seeking funding through debt financing for business expansion and upscaling. How does setting up a security trust help facilitate corporate lending from financial institutions? Okay, over to you.
Okay. So when a company seeks funding through debt financing, one of the critical factors that such company considers is how to meet and manage lenders' expectations. That is, how to look viable and attractive to lenders is very key. So a good strategy, which has always worked and which I believe will continue to work, is by showing transparency around security and assets to be provided as security. Because for lenders, one of the most important factors that determine whether to go ahead with a loan transaction is the security. What collateral are you bringing? What do we have as a fallback or a security for this loan? So a good strategy, like I said, when a lender asks a potential borrower about the status of his assets, and the borrower says, "Oh, I have my assets in a security trust with a reputable trustee like Stanbic IBTC Trustee." There are a lot of other trustees. Actually, we have very competent security trustees in Nigeria. So the lender will be very willing and happy to do business with that borrower. In other words, security trust arrangement enhances lenders' confidence. It improves borrowers' credibility, and it enhances transaction closure. So what do I mean by this? So when you start off by giving or properly arranging your assets in a way that lenders can see, have a visibility of what is being secured, and have a very well structured arrangement, you have kind of laid a foundation for a smooth transaction. So it enhances transaction to close, right? So one of the reasons most transactions will not close are issues around security. So some of the duties performed by security trustees, I think, are also very important and useful for this purpose. So for corporate lending purposes, security trustee serves as a channel of communication between the lenders and the borrower, and even amongst lenders themselves. I think Ekundayo mentioned it, particularly in a syndication. So you have to be that channel of communication between different lenders in a lending transaction. Also, security trustee monitors the security to ensure the lenders are not under collateralized. I think that's where the major issues is most of the times, because you see some borrowers keep borrowing, and then so you need to have someone that is monitoring to make sure that the exposure is well managed, so the lenders cannot be under collateralized at any point in time. So it's part of the duties of a security trustee. And then they also follow through with perfection security. I know in most cases, most of the security trustees, we know they perfected a means of navigating through this process. So as a fiduciary, they have an important duty of trying to protect and balance interests of all the parties, especially the finance parties, both senior or subordinated lenders, and also where you have like shareholder lenders. So it is important. The crux of the explanation is that, so for any company that is considering taking a loan, it is important to show that level of preparedness by having a security trust arrangement put in place. So it encourages lenders to do business with you. Thank you.
Okay, thank you very much, Okey. Another very in-depth response. Still on you, Okey. For companies that are looking to gain funding from financial institutions offshore, can they use a security trust that has been set up in Nigeria for that purpose?
So offshore facilities are very attractive for several reasons. They can be very attractive, which may include maybe accessing foreign exchange, accessibility to foreign currency, foreign exchange, and even for to get attractive commercial terms. There are other reasons why a corporate would want to approach an offshore lender for lending. There are several reasons. But I think for us, what is critical or consideration for an offshore lender, what they would consider before granting a facility to an offshore borrower or a local borrower in Nigeria, for instance, include quality of business and quality of assets of that borrower. Now, in an offshore secured arrangement, most cases, the lender is most likely to entrust the security assets or the secured assets in a security trustee. From my experience, usually they would use a local trustee. For some reasons, again, Ekundayo had mentioned some of those reasons. First, like Ekundayo mentioned, so there are some considerations of legal limitations, and then there are also commercial, considerations, commercial efficiency. So in terms of legal limitations, foreign entities cannot hold legal titles over certain classes of assets. An example is the limitation under the Lagos State Acquisition of Lands by Aliens Law, which restricts the ability of foreign entity to hold interest in land. We have similar restriction across the country. And then there are also other forms of limitations as well, in terms of the ability of foreign entities to access collateral registries, like the collateral registry under the Secured Transaction Immovable Assets Act. And then in terms of commercial efficiency, certain commercial considerations would necessitate the use of local entity as security trustee. So, for example, you need a security trustee that understands local laws. You also need a security trustee that is able to enforce the security. So it is important for an offshore lender to use a security trustee that understands the legal terrain of the jurisdiction where secured assets are located. For instance, a jurisdiction like Nigeria, where the court system could be a bit overwhelming. So you need a local partner that understands that process, that understands the system. For you to be able to enforce your security, even perfecting the security, and even making certain critical decisions around what classes of assets, how to deal with those assets. So I think is a no-brainer. Is important, and in most cases, foreign lenders would use a local entity as security trustee. Thank you.
Okay, thank you very much, for your response. So the next question is for Ekundayo. We've spoken about the benefits of having a security trustee for the lender and also for the borrower. So in situations whereby the lender and the borrower appoint the security trustee, how does the security trustee handle potential conflict of interest in those kind of scenarios? Over to you, Ekundayo.
Okay, thank you. So typically you will have both parties agreeing on who the security trustee for a transaction should be. However, it does not necessarily mean that both parties are the employers of the security trustee. So in order to avoid potential conflict, the very first point I'll mention, the very first thing I will say is for the security trustee to ensure that the documentation is clear as to who its employer is. So that is really the very first thing the very first way to avoid conflict, to see that to determine who your employer is. Therein lies the litmus test for determining where your allegiance lies. That's the first thing. The second thing is you also want to ensure that your security trust deed, which is the document appointing the security trustee, is as clear as possible. Definitely, you can't provide for 100% of eventualities, but you want to ensure that it is as robust as possible to, make provisions for almost anything that is conceivable and the solution to such a thing. And then finally, one other way to deal with conflict is to ensure that all of your decisions are based on competence, are based on good faith and sound judgment. So on the basis of these three, so that if your actions, if the actions of a security trustee on a transaction are being audited or being reviewed, on the basis of fairness, on the basis of trust, and on the basis of competence, you will come out, clean and will not have been determined to breach your fiduciary duty. So I think that the very first thing to do is to clarify in your document who your employer is. That is clear. Once you do that, and then ensure that your documentation as well is very robust and provides solutions for almost any eventuality, and in situations where you are required to exercise your discretion, good faith, good judgment, and competence should be the guiding principles. Thank you.
Okay, thank you very much, Ekundayo. You've heard it from him. Documentation is key. Everything needs to be captured to avoid situations whereby conflicts of interest arise. Now, let's speak to the type of assets that can be placed in a security trust. This is still for you, Ekundayo. What kind of assets can be placed in a security trust? And can any of those assets be domiciled outside the country? Ekundayo, you're muted, please. You're muted.
Oh, thank you. Sorry, apologies for that. I think the simple answer to that is this: any assets can be placed in a security trust as long as it is of value and it is acceptable to the lender. So remember, this is a lending transaction. A borrower has reached out to the lender requesting for loan, and the lender has said, I need you to provide some collateral. So whatever the borrower has that is of value to the lender, that is of value, one, and two, that is acceptable to the lender, can form part of the security trust. To be specific, the most popular one you have is your real estate. So your real estate forms the bulk of what we typically find that falls into your security trust. Other things that security interest can be created on includes your financial instruments, so your bonds, your promissory notes, as long as it's of value and acceptable. So I think the litmus test is this: the item, the object, the property has to be of value and has to be acceptable to the lender. Once these two tests are passed, you're fine. So, in that box, you have things like your real estate assets, you have your financial instrument, intellectual property as well. You can create security interest on them. You can also create security interest on your receivables. And that's where you then begin to have things like your account charge. You can also create interest on your shares as a borrower, i.e., if you own shares in a company and that company is deemed valuable to the lender can decide to take security on those shares. Also, you have your machinery and your equipment. All of these things can all be securitized. Taking it to another level, depending on the type of borrower that you are, and depending on the quantum of the loan, you can go as far as creating security on your licenses. So if you're operating in a space and the assets of the company, so for example, if a telecoms company wants to obtain a loan, and part of the security package is the license, then all of these things can all fall or be part of the security basket. Just to mention one thing, that yes, we have mentioned that the asset has to be of value and then has to be acceptable to the lender. Just to mention that for certain classes of assets, you will need regulatory approvals in order for those security interests to be created. So, for example, if you want to create security interest on, your oil and gas assets, you definitely need the approval of the regulator. And I think telecom as well, if you want to create interest on your telecom license as well, and I think power as well. So for certain classes of assets, you will require the approval of the relevant regulator. And I think you also asked that if these assets can be domiciled offshore. Yes. Let's go back to what I started with. Is it of value? Yes. Is it acceptable to the lender? Yes. And if those two things have been answered, then irrespective of the location, security interest can be created on them. And just the last thing to say is that where those assets are not in Nigeria, while conceptually you can, make them form part of the security basket, you also need to comply with the applicable rules and regulation of the domicile of such jurisdiction. So remember, if you reverse it, if anybody wants to create security interest over land in Nigeria, then the beneficiary of that security has to have the legal capacity to hold the title. So if you flip it as well, if you want to create security interest over an asset that is not governed by the laws of Nigeria, you have to comply with the applicable laws. So to summarize, as long as the asset is of value, as long as the asset is acceptable to the lender, you can create security interest over any asset really, and just ensure that you comply with the applicable rules and regulation.
Thank you very much, Ekundayo. That was a very in-depth response. You've heard it from Ekundayo. As long as the asset is of value and is acceptable to the lenders, security interest can be created over that asset. The next question is for Okey. We have situations whereby a company has pledged their assets as security directly to a bank or a financial institution. What are the inherent benefits of moving that security to a security trustee, as opposed to having it held directly by the bank? Okay, over to you.
Okay. So there are instances where a lender takes security directly instead of appointing a security trustee. This usually happens in bilateral facilities. So in those cases, the lender takes dual or occupies dual role of both a lender and a security holder. However, it is more beneficial, I believe so, for parties in a lending transaction to have a security trust arrangement. We can't elaborate, overemphasize that. Now, the reason for this option, that is why you would want to use a security trustee as against the bank holding the security directly. There are so many reasons, but I will just point out one of those reasons. The first reason is the need to leverage the vast expertise and professionalism and competence in this area. Unfortunately, banks do not have that level of competence, professionalism, and expertise. The reason is security trust role is tedious and time-consuming. So a security trustee, in the real practical sense of it, is the only party who remains or who retains an obligation after a loan transaction has been concluded. Every other professional party, goes away. Security trustee retains an obligation until the loan arrangement or the loan is discharged, or until that relationship ends. So it is an end-to-end process. So you need, for instance, to have in-house a competent portfolio manager to handle a portfolio or a security portfolio. And that's just being competent. You have to know the transaction and know all the rubrics of the transaction in and out. So you need, for instance, to have an in-house tax expert. You have to have lawyers that are cooperating in discharging that responsibility. So you need to have that level of competence, that level of professionalism, which is important. That is why people like to use a security trustee rather than letting the bank to hold security directly. Now, there are other reasons. There is another legal angle to it, and this is in respect of conflict of interest. Now, a bank runs a conflict of interest risk when it performs the dual function of a security trustee and a lender, and that is key, very important. So a security trustee, like I mentioned before, is a trust arrangement in which case the trust or the trustee has a fiduciary duty. So this duty is a common law duty to act in good faith towards the beneficiary. So the security trustee must act in the best interest of all the beneficiaries, including senior and junior lenders in a multiple lending arrangement. So for instance, the bank has to be very careful to avoid a conflict of interest situation where it holds such role. So it has to ensure a clear separation of role in these capacities. So it has to, for example, be able to disseminate information to all the beneficiaries appropriately. And failure to do this would amount to breach of fiduciary duty. So what is the point here? The point is that inherently it is more beneficial to have a security trustee in a lending arrangement. So for the legal reasons of conflict of interest, and then the other more commercial reason of having a professional with expertise, with skills and knowledge and experience in that area. So why would a company who has already set up or created security in favor of the bank transfer it to security trustee? It is for these reasons. And I think, we have seen it happen. Most people do it, and they will continue to do it in the market. Thank you.
Okay, thank you very much, Okey. Okey has spoken to the benefits of having your security with a security trustee as opposed to giving it to the bank directly. So for a company that has pledged their assets to the bank directly as security, is it possible to move those assets into a security trust, and how? Okey, this question is still for you.
Okay. So secured assets, just like every other assets, can be transferred from one party to another. So in this case, we are not just talking about assets. We are just talking about transferring an arrangement, like a right. So, so he is transferring a role of a security trustee or a holder of security from one party to another. It can be done. So it is like transferring a contractual right and obligation. So in other words, the parties, the borrower and the lender, can transfer the security from, for instance, the bank to a security trustee. So as a matter of fact, in most cases, when a second or subsequent lender grants a loan to the borrower, and that second lender, seeks to share the security, so the parties would usually transfer the security from the first lender, which is usually the bank. The first lender, so just transfer from the first lender to the security trustee, and then the security trustee holds and administers the security on behalf and for the benefit of every other lender. But apart from these situations, there are other situations where you can just also, without having a second lender, just move the security from the lender to another party. So what happens in this case? It is a legal process that we call novation that usually happens. So where you do that, you're transferring as a right and obligation. So you novate the existing security document or security deed, and so the novation means the existing holder transfers his rights and obligation to another holder, a new holder. And then you would probably go ahead to also amend the substantive security documents So substantive security documents would include, for instance, a deed of mortgage, excuse me, where you have created a mortgage over a land, or even a deed of pledge, or what we usually call the all asset debenture. So, or security that is creating a charge. So you want to amend those substantive security documents as well, especially where you are dealing with registrable security, like securities that are registered with the land registry or the CAC or the ship registry or wherever. So you have to amend those documents because you now have a new security holder. And then also you would go through the perfection process all over just to deal with those amendments. So you would stamp the documents, and then you have to also register them at the registry and pay the registration fees. So that's typically how it happens in practice. So it is possible, it can be done. You just have to follow the process of, novating the rights and obligation, and then you amend the substantive documents, and then follow it up with just registering them again in the registry. Thank you.
Okay, thank you very much, Okey, for a very detailed response. So the next question is for Ekundayo. So we're speaking to holding companies now. Can a holding company transfer the assets of its subsidiary or other companies into a security trust to obtain loan facilities for itself? Ekundayo,
Simple answer to that is yes, that can be done. Remember the litmus test as to what type of asset can be the subject of a trust, and we said that the asset has to be acceptable to the lender and the asset has to be of value. So in this case, if what has been presented to the lender is or are the assets of a subsidiary, and those assets are of value and are acceptable to the lender, then those assets can be utilized as security for a loan. And this is a typical example of your third-party financing. So the assets under a trust do not necessarily have to be those of a borrower. So, for example, if the borrower has no assets, if the borrower has insufficient assets, but is able to secure the assets of third parties, whether related or unrelated entities, then so long those assets are acceptable and are of value to the lender, the assets can be used to secure the obligations of the third party, in this case the holding company. I think the most important thing that we need to ensure is that the consent of the third party is duly obtained. So if I were acting for a lender, or I was acting for, say, Stanbic IBTC trustees, and you are bringing a third party asset as security for a loan, then I would ask to see the board resolution of that asset. And depending on the type of assets, depending on the quantum of the loan and the sensitivity of the transaction, I may even push as well to say, you know what, I want to see the shareholders resolution, require, confirming that these assets can be utilized as security for a loan. So yes, the assets of a subsidiary and indeed any other third party can be used as security for the loan of a holding company.
Okay, thank you very much, Ekundayo, for your response. Like we've heard earlier, you can have multiple lenders in a security trust arrangement. My next question is for Okey. In having multiple lenders in a security trust arrangement, how easy is it for, lenders to enter the security trust and to also exit the security trust?
So lenders can enter into a security trust arrangement, and they can also exit a security trust arrangement. There are mechanisms for this. I think for the entry, it is usually contractual. So in typical security trust arrangement, the parties enter into a security trust deed or a security trust agreement. So that agreement would have mechanism for entry into the arrangement by additional or subsequent finance parties or lenders. So how does it work in practice? The way it works in practice is that in a typical security trust agreement, there is a pre-agreed form of what we call an accession agreement. Accession just means a right to accede or to enter into an already existing arrangement. So the parties usually, because you're looking at an evolving situation, so you know that subsequent lenders might come into the arrangement. So the parties kind of already front road this process for subsequent entry. So so that's the accession mechanism is usually inbuilt in most security trust agreements. So any subsequent lender, you would sign that accession document, typically saying, so okay, by entering into this accession agreement, I have undertaken to be bound by the provision of the agreement as if I was originally a party. So that's what it just says. So you become a party and you share the rights and obligation of every other party, depending on whatever the terms of the agreement is. So it can be done. Even when you don't have an accession arrangement in an agreement, it can still be done by an amendment. So that is a subsequent lender can always come in by amending the existing agreement. So it's a contractual arrangement. Now for exit just means taking out a lender or exiting a lender from an existing security arrangement. So how does that happen? We are dealing with a lending situation. So what is the interest of every lender? Interest of every lender is exposure. That is the money that has been disbursed. So once that money, this obligation of that borrower has been discharged. If obligation is discharged, then the lender has nothing doing in that arrangement. So usually, once a loan has been repaid or the obligations owed to any lender, in a security arrangement situation, security trust arrangement has been repaid. You would usually have received a letter by that lender confirming that the loan has been repaid. So once that is received by the trustee or even the borrower, then you can go ahead and then exit the lender from the arrangement. So apart from that, so you also want to look at the agreement itself. In most cases, you have to amend the security trust agreement. This is usually a simple amendment process. So you are just amending references to that lender in the document or in the security trust agreement. So you amend it by deleting all the references to that lender. So the lender is out of the picture. Yes, it's possible. It can be done by the mechanisms built into the existing agreement. It can be done by a subsequent amendment, and then so that's the process.
Okay, thank you very much, Okey. Now, my next question is for Ekundayo. In setting up a security trust, is setting up a security trust the same for firms that have landed property or assets registered with the Land Registry, or, for instance, Nigerian Export Processing Zones Authority? If no, what are the intricacies with these kind of assets?
So, your question is in relation to parcels of land that are situated within and outside of the free trade zone, really. So setting up a trust, creating a security interest over land that is outside of the free trade zone is simple and clear. All you need is conduct your title search and at the relevant lands registry, and in case of for a corporate borrower, also conduct your search due diligence at the Corporate Affairs Commission. And once that is done, and there are no encumbrances, and the due diligence report gives the transaction a clean, gives the security, the assets a clean bill of health, then you can proceed to execute your deed of mortgage and file same at the Lands Registry to perfect same, and then also file it at the Corporate Affairs Commission. Now it gets a little tricky where the land involved is situated within any of the free zones across the Federation. And the reason for that is this. Recall that on this webinar, we've mentioned that under Nigerian law, for you to hold title to land, you need to have legal capacity. And the legal capacity to hold title to land is really, you have to be a Nigerian, either a Nigerian individual or a Nigerian corporate, as the case may be. Now, there are legal arguments for and against, but in my firm, we choose the conservative route because we don't want to test the jurisprudence with any client's transaction. And as such, our view is that, entities that operate within the free trade zone, within any of the free zone, does not have legal personalities. If you look at the Companies and Allied Matters Act, if you look at the most recent amendment in 2020, I guess, it specifically says that, companies have legal personalities. In other words, legally speaking, a company is a person and a company can do what a private individual can do. However, you do not have any such specific provision in the NEBSA Act, and it would be a far stretch to imply that. Now, what does that mean? What that means is that I do not think, in my opinion, that a free zone entity is a legal personality, and also it's not a Nigerian entity. Now, I'm going to dive into a bit of legalese here, but I'll try to make it as clear and simple as possible. While the free zones have lands on which they conduct their business, and while the free zone area has been statutorily vested with certain economic benefits, there is actually a section, I think 24 thereabout, in the NEBSA Act that says that except for the specific benefits that have been conferred on the free zone entities, the laws that apply within Nigeria, i.e. the laws that apply within the customs territory, shall also apply within the zone. In other words, the fact that you are operating within the free zone does not exclude you from the laws that apply within the customs territory, which is Nigeria. And one of those laws is your Land Use Act, which brings us back to what the Land Use Act says, that, land is being held on behalf of Nigerians. And what that simply means is that whether or not the land is situated within the free zone or outside the free zone, the only person that can hold title to land is a Nigerian entity. Now, I've sort of laid at a high level a foundation to say that free zone enterprises are not Nigerian companies and cannot hold title to land. So my advice is that if you are dealing with an asset within the free zone, you need to ensure that the title issue is well clarified. And if you have to take that asset, then ensure for the purpose of enforcement that the title to that land, even though it is within the free zone, that the title to that land is actually held by a Nigerian entity so that you can have a valid title. So generally speaking, creating security interest either within a free zone or outside of a free zone, they are very similar processes. The only difference here being that you need to be extra careful with the nature of the legal title for the land within the zone. And you also, that really is the case. And you may just need to have one or two filing obligations with the zone manager and NEBSA as the case may be. Yeah, that's the short answer to that.
Thank you, Ekundayo, for really dimensioning that question. We've heard about the intricacies for assets that have been registered in land registry or that are within the free zone. So we've spoken about the benefits of having a security trust. We've spoken about the administration of a security trust. Now, can you tell us about the cost implications of setting up a security trust? What are the costs involved? Ekundayo, this question is for you.
So the cost involved in creating a security trust will be determined by the nature of the assets over which you want to create that security interest. So we'll go with the popular one, which is your real estate. Now, if you want to create a security interest over your real estate assets, typically it will be in the form of a legal mortgage. Now, in giving you these costs, I'm going to assume that the borrower is a corporate entity. And if I make that assumption, then I'm also going to stay with one of the most popular markets, for real estate, which is Lagos. So having assumed that the property is in Lagos and also that the borrower is a corporate entity, then the following cost will apply to the creation of a real estate of security interest over land in Lagos for a corporate borrower. One, at the lands, you'll have to perfect at Lagos State Lands Bureau. You'd also have to file your documents at the Corporate Affairs Commission. You'd also have to pay stamp duty to the Federal Inland Revenue Service, the stamp duties unit of the Federal Inland Revenue Service. And for each of these three regulators, there are fees to be paid. For the Lagos State Lands Bureau, governor's consent fee is 0.25%. Registration fee is 0.5%. And I think I should quickly make this distinction. Unlike the Corporate Affairs Commission, the CAC, and the stamp duties unit of the Federal FIRS, Federal Inland Revenue Service, unlike these two entities that are conversant with the whole loan documentation and security type arrangement, the people at the Lagos State Lands Registry and by extension any other lands registry are really not familiar with this thing. And as such, they see themselves as revenue agencies. So, for example, if your loan is, say, 10 billion, for example, with a 10 billion naira loan, if you put in the deed of legal mortgage 10 billion at the stamp duties unit, you can put a loan of 10 billion in your document. And when you get to the stamp duties office, you just tell the commissioner, oh, I'm stamping for 10%. And the stamp duties commissioner will stamp for 10% and give you a receipt for 10%. You're fine. You can also do the same thing at the CAC. But if you do the same thing at the Lands Bureau, once the Lands Bureau see any amount, they will charge you up to the max of that amount. So 0.25% of the amount in your document. And you and I know that the fact that you have a loan amount does not mean that that is the amount you want to secure for. And this is a secured transaction. So you should only pay the applicable regulatory fee on the secured amount. But the Lands Bureau does not know that. So what we typically do for situations like that is that your loan agreement has the loan amount, which is fine. But in your deed of legal mortgage, which is where the security document that will be filed, what we usually do is we ask the parties upfront to determine the initial secured amount. So it is that secured amount that will reflect in the deed of legal mortgage. So for a 10 billion naira loan, for example, if the parties agree that they want to initially secure the loan for, say, 10%, which is 1 billion, then we will describe in the deed of mortgage that the secured, so we will be describing not the loan, but the consideration will be in consideration for the secured amount. The borrower hereby creates security interest for the lender in favor of the security trustee. And the definition of your secured obligation will be the secured amount. Now, I know somebody is asking, okay, if you put 1 billion in the document, what then happens to the remaining 9 billion? Remember that your 1 billion is the secured amount, and your 1 billion is being put in the deed of mortgage, which is the document creating the security. So you are covered because we are dealing with the secured amount. But to then give, the security trustee the flexibility of upstamping, what you then do is you define your secured obligation as one, the 1 billion, which is the secured amount, and then two, you put a generic description to say the secured obligation is the 1 billion and any other money or monies that have been, is being, or will be advanced by the lender to the borrower. That way, you have clearly stated your 1 billion, and then you have, in generic terms, captured the entire amount that is unsecured, but that you do not require to disclose at this point. So at the lands registry, you pay 0.25%, and you also, for consents, because you need the consent of the governor to create to transfer the legal title, you also pay the sum of 0.5% for registration fee. Now, because the borrower is a corporate entity, the amount payable as stamp duty is payable to the stamp duty unit of the FIRS, and at the FIRS, the cost, the stamp duty amount is 0.375 of the sum secured, not of the loan amount, but of the sum secured. And then at the CAC has, done a revision on the price, on their fees, as part of the whole ease of doing business. And before now, it used to be 1% for private companies and 2% for public companies. But with the new regulation now, the amount payable to the CAC is 0.35% for either public or private companies. So that's the total amount that you pay. Lands in Lagos, 0.25 plus 0.5, that's about 0.75. And then at the stamp duties, 0.375, which brings you to a little above 1.1 or 1.2. And then at the CAC, Corporate Affairs Commission, you pay 0.35, which brings you to about 1.5% of the secured amount. So 1.5%, I think, is the average amount you pay for perfecting your security document at the Lagos State Lands Bureau, the Federal Inland Revenue Service, and also at the CAC.
Okay, thank you very much, Ekundayo. He's given us a run-through of all the costs involved. We'll be wrapping up the panel discussions very soon. So please, you can start putting your questions in the chat box. I'm sure we have a lot of questions. Please start putting your questions in the chat box. Before we wrap up the panel discussions, we're going to be getting a real-life example from one of our panelists. We've been talking about the role of a security trustee. We've been talking about all the technicalities involved. Now we want a relatable example where the security trustee played a vital role in protecting the interest of all the parties involved in a transaction and led to the eventual success of that transaction. Ekundayo will be giving us a story time. Ekundayo, over to you, please.
Okay, so I definitely can mention the parties involved, but this was a bond. It was a bond transaction pre-COVID. Yeah, it was pre-COVID. And the bond was actually designed as a secured bond. So the issuer was issuing bonds, and then as a credit enhancement, the issuer offered to create a mortgage over one of its choice assets somewhere in the Lekki axis of Lagos. Now, the question then is this: you have described the bond. That's just so see the sequence. The bond is being marketed as a secured bond. In other words, from day one, when the bondholders give their money to the issuer will give a secured asset as the collateral for that bond transaction. This was the challenge. The challenge is, at the time the transaction document will be, and if you understand the way the capital market works, is once you sign your transaction document, you open up your offer, the monies come in, and then you move the money to the issuer, who in this case is the borrower. However, and remember, the story was, we give you our money, you give us a secured interest. But the question then is, we are giving you the money, but we don't have a deed of legal mortgage at the time of signing and at the time of giving you our funds for this transaction. So it then became an issue, because on one hand, the issuer is saying it's a secured bond, but on the other hand, at the time of the transaction, at the time of executing the document, no security exists. So the question then is, how do we resolve that issue? So in the spirit of full disclosure, and in order for and remember when we were talking, and I think Temitope asked me, why do you need a security trustee? And one of the reasons I said was that if you have a syndicate of lenders, then you have two, you can have, for bilateral loans, you can have up to 10, 20 lenders. But for bonds, you can have X number of bondholders who are the lenders. And in that case, you definitely need a security trustee. But this is the problem. The security trustee is the one that represents the interest of the bondholders. And the security trustee is the one that is supposed to ensure that at the time the transaction documents are being signed, at the time the money is being given to the borrower, the secured assets exist and is available for their protection. But then the security trustee then asked us, Ekundayo, at the date of signing, we know that we cannot have these assets secured. We definitely can't get governor's consent in 2 days or in 1 week or in 2 months. So what do we do? So we then advised them to, yes, we advised them to disclose this in the transaction document so that a month after the transaction has been signed and completed, no bondholder is coming to tell you, show me the evidence of this secured asset, which you should have ensured has been given to us. So what we told them to do for that transaction was to disclose it it was a series trust deed. Yeah, it was that series trust deed, I remember. So it was fully disclosed in the series trust deed to the bondholders that, yes, this transaction is designed as a secured asset. However, as at the date of signing, the security, the process of perfecting the security would not have been completed. As such, the trustee is now granting a grace period of 1 year to the borrower, to the issuer, to ensure that the security interest is perfected. So that way, as a security trustee,
Hi, Ekundayo.
okay.
It seems that okay, he's back.
Yeah, I'm
Yes,
back. I
we can
think there
hear
was a
you.
glitch. Yeah, there was a glitch.
Okay.
So
All right.
So the way we structured it was to ensure disclosure in the transaction document to say that yes, it is being designed as a secured bond. It's going to be a secured bond. However, the security would not have been perfected up until a year. The security will be perfected before the first anniversary of the bond. And if that security is not perfected, then it becomes an event of default. So that, the bondholders are then protected. So that was what we did in order to protect the security trustee. Otherwise, any of the bondholders could have, challenged and sued the security trustee for misrepresentation, i.e., you told us that this asset was secured, but the asset was not secured, and you still went ahead with this transaction. So that's one example of how it's a real life scenario where we were able to navigate and protect the security trustee. Yeah. Yeah, that's from me, but I'm sure I'm sure they will have 1 or 2 things to add to it as well.
Okay, thank you very much, Ekundayo. Okay. Do you have anything to add to that?
I guess it's just to it may not be actually any specific real life experience, but it's just to buttress the point that Ekundayo mentioned, the importance of making sure that as a security trustee, you do not expose yourself to situations where you would be breaching the fiduciary duty to beneficiaries, especially when you are dealing with parties who are outside, the transaction itself. So, for instance, in a bond or in a capital market transactions, where the beneficiaries do not even have a line of sight of the document or even the negotiation and all of that. So you have to be careful. that your beneficiaries do not have an idea of what you've done. So you have to, just make sure you protect yourself. So there are so many examples like that from transactions where we've done even in the usual lending transactions between a bank and a borrower, right? So in most cases, I think for us, what we have seen from experiences where, trustees have been accused of not taking good care of documents. Maybe you ask the trustee to send you some title documents and they can't find it, and they'll be holding these documents for a while, So in certain cases, you now have to like threaten, oh, I'm going to sue you because you are breaching a duty, an important duty. So we have seen such cases before. So issues around negligence, issues around, just being careful and making sure that you're taking a very important responsibility, just not just for the lenders, but also the other party, borrower. Yeah.
Okay, thank you very much. Yes, thank you very much, Okey. And Ekundayo, thank you very much for, giving us that real life example. I think this brings us to the end of our panel discussions. So now we'll be moving to the second phase of this webinar, where we'll be taking questions from the audience. Please drop your questions in the chat room. The chat is open now. Any questions you have, please drop it in the chat room. We'll pick your questions up from there and send it to the panelists for their response. Okay. Okay, so I can see a question here. So the question is, hi, I would like a brief summary on the role of security trustee in an enforcement security scenario. Are there challenges a security trustee will encounter in enforcing security in Nigeria? And how do you tackle those challenges? Interesting question. Who would like to take this? Enforcement scenarios.
Whoever you ask to.
As you responded, Ekundayo, this question is for you. Okay,
anyway,
next.
I think one of the challenges you can face during an enforcement scenario is where your security interest has not been you are not fully covered. You are not secured up to 100% of your total exposure. So remember in the example I gave, you probably are secured for 10% of the total loan amount. And then for whatever reason, an EOD event comes up and you need to enforce. Now, for you to enforce, remember, under the law, you are only secured to the extent to which it's a bit of repetition. You are secured to the extent to which you are secured. So if you have a 10 billion naira loan exposure and you are only secured for 10%, it means that only that 10% is guaranteed, and then you are unsecured for the 90%. So what we typically find, and what we typically advise is this: you, the security lender, you know the cost of securing your client up to 100% from day one. You know that cost. Now, for convenience, you don't have to secure that. But part of the things you want to do is, while the parties would have agreed to be secured up to 10%, you, the security trustee, you want to have the funds to secure your lender up to 100% in an enforcement scenario. And how does it happen? So both of them fall out. Someone is not paying up their loan, and you want to take over the assets, as it were. Now you need to move from the 10% cover that you have up to 100%. And how do you move? You need to pay up you need to upstamp your documents at the FIRS, at the Lands Registry, and also at the Corporate Affairs Commission. Because if you have to sell, if you have to exercise your power of sale, you need to show to the purchaser that you are exercising your power of sale, which has arisen. And then, you have to show 100% ownership of that security. So one of the ways by which you can remove this challenge is to ensure that you are being kept in funds from day one. So you are only secured 10%, but the balance of 90% regulatory fees needed to take your lender to 100%, you have that fees, and if push comes to shove, under a week, under 3 days, you can quickly upstamp your documents and your lender is, totally secure. Another challenge you can have is if you do not get all your documents beforehand. So, for example, if you are doing a share charge, for example, then you want to ensure that, all your share transfer forms are signed, albeit undated. You want to ensure that, because in an enforcement scenario, the parties are not in good terms and they are fighting each other, and you can be sure that your borrower may not be as cooperative and as willing as they were when they were begging or when they were applying for the loan. So you need to ensure that you are putting funds. You also need to ensure that you have all the documents required to enforce and take control of that asset. Because even if you have to resort to say, for example, seeking an order of the court to get some money out of a property or to take possession and what have you, one of the things you want to show to the court is, I have full rights to this. Because if you are going and telling them to get some money out and they are able to show that you only have 10%, then that may be an issue. And then you also don't want to subordinate yourself to other lenders as well. So, these are some of the issues. Ensure that you are informed, ensure that you are properly documented, so that, in a split of a second, you can take full possession of your assets. So these are some of the things I can think of right now.
Okay, thank you very much, Ekundayo, for that very in-depth response. We have more questions coming in. I have a question here. It says, please throw more light on what a security trustee should do in a situation where the assets brought in by the borrower are under collateralized. So we have a situation whereby the exposure, the exposure of the facility is way above the value of the assets that are in the trust. So just to clarify, that's what it means when we say under collateralized. Okay, do you want to take this question?
Oh yeah. So in a situation where you find out that the borrower has taken so much loan to the extent that the obligations under those loans cannot be over and above the security that you have. So, which means that if there is an enforcement, the secured assets will not be able to satisfy those obligations. So even if you have to dispose those secured assets, you will not be able to realize the secured obligations. So in that case, you are uncollateralized. So, and that's a bad situation to be in as a lender. So no lender wants to find itself in a situation where the value of the security is much lower than the value of the loan or the value of the exposure. So if you find yourself in a situation where your lenders are under collateralized, first of all, I think the most important thing you have to do is to notify, because your beneficiaries are the lenders. You notify the lenders, and then the lenders will have to request for additional security. Excuse me. So the lenders would have to request for an additional security from the borrower, which means they would be asking for more assets to be brought into the pool of security. Another way you can also achieve that is to, if you have some assets that are registered for a value that are below the actual value of those assets, like what Ekundayo described before, where you register security for a nominal amount as against the total amount of the security. So in that case, you will immediately be calling for an upstamping. So you have to go and increase the value of the security. So if you have a 1 billion naira asset, worth of assets that you have registered for, let's say 100 million, so you'd probably go and seek for an increase of that security by increasing the value of the security up to the amount that has been lent. So up-stamping is one. Another one is to ask for more assets to be brought into the pool of security. I think that's typically the way you can go about it.
Okay, thank you very much, Okey. We have another question in the chat room. How do you resolve an issue where the borrower has paid 90% of the amount borrowed, but an event of default has occurred on the 10%? Will the entire security be disposed to offset the 10%, even though the security is about 170% of the amount borrowed? What will be done? Restructuring or legal action? Okay, do you want to take this question?
Okay, so this is more of a commercial point for the lenders. So if you have an exposure that has been reduced for up to 90%, and you're faced with a default on 10%, so the question is, how do you want to deal with it? So there are several commercial decisions you have to take. You have to look at the business itself. You have to look at the borrower. Is the business still viable? Is the business going on well? Would you be able to realize your exposure? Let's say if you restructure the loan, or do you want to kill the business because of 10%? Do you want to sell off the assets and all of that? So I think for a 10% exposure, commercially, most lenders, because this is a business relationship, is a relationship that everybody wants to sustain, everybody wants to keep going. So I think mostly the most commercial options would be to restructure, especially you're looking at a very very minimal amount of risk here. So you try, first of all, to restructure the loan and see how you go about it. And probably you can come back later along the road to have a reassessment. But I wouldn't think an enforcement will be the first option in this scenario. So even if it comes to an enforcement, there is still a lot of commercial decisions to be made. So you have to look at what are the assets that you're looking at? What kind of assets? What can you realize? Do you want to sell the assets, or do you want to just to use other alternative measures, like you want to put in place certain obligations on the company in terms of how those assets are used. So, for instance, if it's an asset that is yielding fund on periodic basis, maybe you want to tighten control on those assets, how those funds are managed, so that you have more control, right? So, or even if there are some assets that you need to keep turning around to be able to to get some liquidity, you want to have more control on how those assets are dealt with. But I don't think selling off the assets or disposing the assets would be the first option.
Okay, thank you very much for your response, Okey. I think we can bring the Q&A session to a close, and also the webinar as well. Thank you very much to the panelists. Thank you for your responses, very detailed responses. Thank you for sharing your wealth of knowledge with us. I personally have learned a lot from this session, and I'm sure the members of the audience have learned a lot too. Thank you to the audience for your attendance. Thank you for your questions. Thank you for making it very engaging. Now we'll be taking the closing remarks. Seyi Agbari, Head Institutional Trust and Loan Agency, Stanbic IBTC, will be giving us the closing remarks. Over to you, Seyi.
Thank you, Temitope. Good afternoon, ladies and gentlemen. On behalf of Stanbic IBTC Trustees, I want to thank you all for taking out time from your busy schedules to join today's webinar, which has been enlightening, to say the least. We hope that this has been worth your while. We trust that you have found the discussions and knowledge shared today valuable in deepening your understanding of corporate finance and the role of the security trustees in fostering the seamless execution and closure of lending transactions. At Stanbic IBTC Trustees, we don't just provide trust services, we forge partnerships built on trust, expertise, and unwavering commitment. We understand the nuances of corporate lending arrangements, and we excel in safeguarding the interests of both lenders and borrowers, meticulously monitoring compliance, navigating complex legal frameworks, and managing complexities of financial transactions. For more information on our services, please send us an email at callme@stanbicibtc.com. We will drop this in the chat room for you. We want to appreciate our speakers for sharing their insights and expertise with us. Your contributions have added immense value to this conversation, and we are grateful for your time and efforts. Thank you very much, Okey, and thank you very much, Ekundayo. Thank you also to our amiable moderator, Temitope. To everyone who joined in or watched this replay, the replay after now, we want to encourage you to consider all the insights from this session and take the necessary steps required to ensure our businesses are protected. Stanbic IBTC Trustees is here to support your journey to success and drive our country's economic growth. Remember that you have the right partners in us, and we are committed to helping you to achieve your business goals. Thank you once again for taking out time to join us today, and we wish you the very best in your future endeavors. Do have a wonderful evening. Thank you, everyone. Bye.
Thank you very much, Shay, for the closing remarks. Also to mention that if you have any questions for us or need any clarifications, our email is in the chat box. So you can go to the chat box to get our email address. We'll also put our phone number in the chat box as well, so you can call us directly. We'll be happy to take any of your questions that you have and provide clarifications. If you're interested in any of our service offerings, please reach out to us. Thank you very much for your attendance and enjoy the rest of your day.
Thank you.
Thank you.
Thank you.